Leader of the Opposition.
Thank you, Mr President. I lead for the Labor opposition on the Transport Administration Amendment Transport Entities Bill 2017. The Labor opposition opposes the legislation before the House for three principal reasons. It aids and abets this government in erroneously removing...
Order. Could I just have the Parliamentary Secretary move that this be read a second time, please? This bill be read a second time. We'll just correct it.
Mr President, Mr Deputy President, I move that this bill be now read a second time.
Thank you. The Honourable Adam Searle.
Thank you, Mr Deputy President. The Labor Party opposes this legislation for three principal reasons. It aids and abets this government in erroneously removing billions of dollars from the budget bottom line, using an accounting trick to falsify and make the budget look better than it really is over the forward estimates, and thereby seeking to con the wider public. Secondly, under the model proposed by this bill, the safety of train services in this state will be at risk, placing at risk the train-going public and winding back previous reforms directed at promoting public safety in connection with rail transport. And finally, the legislation will allow for the privatisation of rail assets in this state by a ministerial directive without further deliberation or decision by this Parliament in a way that I don't think honourable members in this place or the other place are fully aware of, and which certainly the public is most unaware of. The bill proposes a staged process whereby Sydney Trains, the Metropolitan Services and the New South Wales Trains, Regional New South Wales, deliver railway passenger services. Rail Corporation will be the asset manager and will be assigned further asset management functions. There will be a residual transport corporation to assist in the wind-up activities that transport agencies no longer need to undertake. And finally, Rail Corporation will be turned into the Transport Asset Holding Entity, TAHI, and converted into a state-owned corporation. The term administration in the bill is misleading and doesn't reflect the enormous scope of the legislation. Due to the TAHI accounting changes, the budget result has been improved according to the 2015-16 state budget by the following amounts. For 15-16, the budget surplus is artificially inflated from $713 million to $2.5 billion, increasing the surplus by $1.8 billion. For the 16-17 year, the budget surplus is artificially inflated from $756 million to $3.1 billion surplus, an increase of $2.4 billion. In 17-18, the surplus is increased from $811 million to $2.6 billion surplus, a further $1.8 billion increase. And from 18-19, the surplus is artificially inflated from $895 million to $2.3 billion surplus, a further $1.4 billion inflation. Over the forward estimates, the budget bottom line is improved by $7.4 billion without actually changing the money in or money out. It's just an accounting trick to try and con the public and the money markets that this government is actually a reasonable economic manager. When you peel back that veneer, you see that's just not so. In June of last year, the Rail, Tram and Bus Union New South Wales Secretary Alex Classens indicated that the inclusion of the Transport Asset Holding Entity in the budget should be a major concern to commuters and workers because it is another step towards the privatisation of public transport services. In June 2015, a columnist with the Australian newspaper, Adam Crichton, said, and I comment, and I quote, "The New South Wales budget reminded us that governments with their vast array of on- and off-budget sheet entities can, were it not for the creation of an independent agency, the TAHI, to oversee the transport infrastructure, the much-flaunted surplus would have crashed from $2.1 billion this financial year to $700 million next year. Instead, the surplus is rising to $2.5 billion, then $3.2 billion. Almost 70% of the $10.6 billion worth of surpluses projected over the next 4 years depends on a new transport asset holding entity, a public trading enterprise similar to Landcom or Sydney Water, outside the general government accounts that will manage the state's public transport assets on a consolidated basis." So we can see that billions of dollars are wrongly, we think, removed from the budget. Bottom line, the government created the TAHI asset from 1 July 2015, as a public non-financial corporation responsible for managing the rail assets separate from providing railway passenger services, and this was done to move it effectively off budget. And the government and the Treasurer at the time, now the Premier, stated that this was consistent with the Australian Bureau of Statistics classifications. In fact, if you look at budget paper number 1 from last year, page 1-2, you see quite a good illustration, box 1.1, which states that in accordance with government finance statistics classification, the Australian Bureau of Statistics has classified Tahi as a commercial public non-financial corporation. Now, if the Australian Bureau of Statistics had in fact done that, why the need for the legislation? Because the government has already moved to bank the savings. As you can see, but for Tahi to be taken off budget, it needs to make a commercial return of at least 7%. And this is very difficult, Mr Deputy President, because rail assets are not profitable in a straight profit-loss sense. There are billions of dollars, tens of billions of dollars worth of rail assets that are a depreciating asset. And of course, as all members would be aware, rail journeys are publicly subsidised to the tune of about 73%. Fares cover less than 30% of the cost. So how then can this new entity actually make a commercial return of at least 7%? I will return to this theme, but it's clearly not without not only smoke and mirrors, but of course having to sell off assets reposed into this new body. The budget, as I said, has been artificially improved by this accounting trick, and the government has already banked the savings, as you can see from that page from the budget papers, page 1.2. You can see the $7.4 billion already banked in last year's budget, even though there was no legislation. So the ABS has apparently reclassified the holding entity. The government's banked the savings in the budget, so why the legislation now? Could it be that the ABS is not satisfied with the government's work to date? Or maybe the classification, if it has taken place, is conditional upon legislation. Certainly the government has been lacking in transparency around the process, but proper process would have seen legislation occur before you cooked the books, Mr Deputy President. They should have sought and obtained parliamentary approval before engaging in this grand deception. Our understanding, of course, is that the ABS has informed the government that the current arrangements regarding the Tahi are not sufficient to enable it to be taken off budget. The government, in our view, therefore, has erroneously banked the savings and has now been sent back to the drawing board to obtain parliamentary approval and to lock the assets into a state-owned corporation, ostensibly governed by an independent board. Clearly, the ABS is not content with the government in the current arrangements having the ministerial control and direction. They want it in the hands of a state-owned corporation which allows them to claim it's more independent of government. The government now wishes to convert the Tahi into a state-owned corporation with the main objective of it becoming a successful business. If the bill does not go through, the Tahi will need to be added back to the budget, which will significantly deteriorate the budget position and possibly lead to a budget deficit in future years. But even if this bill does go through, there is a strong possibility that the ABS will be unsatisfied with this state-owned corporation arrangement, being able to make a commercial return of 7%, and the Tahi would still need to be added back on budget. So we oppose the legislation for that. Under this model, the safety of train services, we think, will be at risk. The separation of asset ownership, Tahi, from rail service delivery, Sydney Trains and New South Wales Trains, is what the New South Wales Labor government introduced in response to national competition reforms in 96 to 98. In 2000 to 2001, the New South Wales government witnessed the risks with that approach. For example, the asset holder, the Rail Access Corporation at the time, dropped the ball on ensuring that its assets were maintained properly because of the need to operate commercially and return dividends to Treasury. One way to achieve this was to reduce costs by extending the maintenance cycles as part of their asset management strategy. The risk is even higher with the objectives and functions of Tahi, the new Rail Access Corporation, which is now 100% focused on being commercially successful and maximising its net worth to New South Wales. It's a classic asset manager with no service safety responsibility. This is appropriate for a property fund, but not for managing assets to run rail services. The objectives and functions of Sydney Trains and New South Wales Trains do not compensate for this. The primary objective of both is to provide safe services with an efficient, effective and financially responsible manner. While the bill says that this objective is one that supersedes all others, the other objectives also require it to be commercially successful and to maximise net worth. So in its objectives, I think at clauses 10 and 11 of the proposed bill, you have this tension set up which undermines, we think, the objective of public safety. There is a risk that the combination of these commercial objectives and the need within the primary objective to operate efficiently and financially responsibly will inevitably mean that safety is not the primary focus of management, and of course there will be consequent risks to the public. This risk is even higher as Sydney Trains and New South Wales Trains have other functions which have more to do with running a diverse transport business than running rail services. Lessons in government show that in the aftermath of the rail accidents, the more competing objectives and functions these agencies have, the less focus there is on safe rail services. It will be inevitable that the management of Sydney Trains and New South Wales Trains will become seduced by the opportunity offered by their objectives and functions to build a successful and diverse transport business. The three protections referred to in the Minister's second reading speech to ensure the primacy of safety have all failed previously and led to the merging of previous agencies into one entity. One of the safeguards is that the Transport Secretary can direct Sydney and New South Wales Trains and also sits on the Tahi board. Now, of course, other statutory stocks within New South Wales have caused problems for governments because they operate within their commercial mandate, and directors, despite being appointed by government, take their director's obligations to act in the best interest of the company, not the government, seriously. The Secretary, of course, will be only one voice on the board of up to 7 people and will only be able to direct Sydney and New South Wales Trains to effectively prioritise safety above all their other functions if he is fully informed by those organisations of all risks in a timely way. Relying on this assumes information asymmetry which does not exist. Tahi will need to comply with an operating licence issued by the Minister, but previous experiences in government show that the board rarely refers to operating licences when making investment decisions. Relying on contracts to ensure asset managers focus on passions of safety is a recipe for failure. It's a disaster for public confidence in the rail system if the Minister has to enforce the operating licence to improve the focus on safety. 3, the SOC Act gives the Minister for Transport the capacity to direct Tahi to act in the public interest. This is true but not foolproof. First, the board can resist this if they feel the direction undermines their commercial objectives, and secondly, the Treasurer, as the Tahi shareholder, must agree to it. If the Minister for Transport has to use this power to make Tahi focus on asset safety, it shows the model is fundamentally flawed and has failed. It took the death of numerous railway workers in the tragic Glenbrook rail accidents in accident 1999 for it to be understood that public passenger rail operations should not be split up. They should be integrated. The New South Wales Labor government combined the rail infrastructure owner and rail infrastructure maintainer in 2001 and then combined them all with the passenger railway service operator for the metropolitan area. This government is now splitting up rail operations once more. We oppose the bill because the huge safety issues and ramifications that will arise out of the new arrangement. As I indicated, the legislation will allow for the privatisation of the rail assets. Tahi is expected to run out of money by year 4. Therefore, the government in 2020 and beyond will be running an entity required to make a 7% return, but draining significant amounts of public expenditure. It's quite clear that privatisation will be the tool to cover losses to be made in year 4 and onwards. By setting up the Tahi as a state-owned corporation whose main objective is to run a successful business, the government is preparing for the Tahi to be privatised. Under clause 10.1b, the Tahi is to be a successful business and is to operate at least as efficiently as any comparable businesses and to maximise the net worth of the state's investment in Tahi. Mr Deputy President, the public have had a gutful of privatisation and we won't stand for it and we will oppose the legislation for this reason, among others. Schedule 1 of the bill changes the way Sydney Trains and New South Wales Trains are established. Currently they're subsidiaries of Rail Corporation under the Transport Administration General Regulation. They were created as subsidiary corporations to Rail Corp in 2013 because the New South Wales Government could do that by making a regulation under Section 55 C of the Transport Administration Act. The government preferred to do that because it wanted to avoid putting legislation to Parliament, where of course you had to run the gamut of the upper house. From 1 July 2013, Railcorp remained in existence as a statutory corporation, effectively as owner of all public transport rail assets. Sydney Trains and New South Wales Trains had a right to control and manage rail infrastructure on which they run passenger and bus services on the Railcorp-owned network under the terms of contracts and licences between Railcorp and the subsidiary corporations. Sydney Trains and New South Wales Trains will become statutory corporations in their own right. Their statutory obligations and functions will be the same as they are now. Both Sydney Trains and New South Wales Trains will be rail authorities under Schedule 6 capital A, and item 56 of the bill spells that out. Each of them will be a rail infrastructure owner as defined in Section 3 of the Transport Administration Act in respect of rail infrastructure facilities they manage or control. The land on which the rail infrastructure facilities are situated will continue to be owned by Railcorp until it becomes TAHI when Schedule 2 of the bill commences. Presumably the current contractual arrangements under which Sydney Trains and New South Wales Trains control and manage its rail infrastructure on which they run services will continue in existence. Once Schedule 2 of the bill commences and Railcorp is converted to TAHI, this can potentially change, and I'll come to that later. Under Clause 23 of the bill, government funding of Sydney Trains and New South Wales Trains will be sums advanced directly by the Treasurer, appropriated by Parliament for Transport for New South Wales purposes and allocated by Transport for New South Wales or as otherwise appropriated by Parliament for each agent specifically. They'll still be able to collect revenue from commercial activities, authorised investments and fines and penalties. Item 27 of the bill permits each of Sydney Trains and New South Wales Trains to make orders setting charges, including fares similar to existing powers in existing legislation. Employment of staff will be under the same provisions that exist now, and that won't be changed. There is, however, a significant change to the power of the Minister for Transport to transfer assets, rights and liabilities out of transport authorities. Current Section 94(1) of the Transport Administration Act empowers the Minister to transfer assets, rights and liabilities from rail authorities to another rail authority, a subsidiary of a rail authority, a state-owned corporation, the Crown or any other person or body acting on behalf of the Crown or a local council. The current definition of a rail authority includes Railcorp, Transport for New South Wales, or any other person or body prescribed by the regulations, the SRA Residual Holding Corporation, the Transport Secretary, and any other person or body prescribed by the regulations. Items 34 and 35 of the bill change the power so that assets, rights and liabilities of a transport authority may be transferred by ministerial order, and the definition of a transport authority will include a rail authority, such as Railcorp, Transport for New South Wales, or any other person or body prescribed by the regulations, the SRA Holding Corporation, State Transit Authority, RMS Sydney Ferries, Transport Secretary, and any other person or body prescribed by the regulations. And this is a very significant change that will allow assets, rights and liabilities of all operating agencies in the transport portfolio to be transferred out by ministerial order. Particularly item 36. Assets and rights and liabilities include real property, personal property, plant equipment, structures severed from ownership of land, contracts, licences and legal liabilities. Because the definition is so broad and includes any other person or body prescribed by the regulations, the government will be able to make regulations prescribing any person or organisation as a transport authority. For example, a private sector bus operator could be so prescribed and the assets of the STA could be transferred to it. Or Sydney Motorway Corporation, for example, a government-owned but essentially a private company, could be prescribed in a regulation and RMS assets could be transferred to it. And then the Sydney Motorway Corporation could subsequently be sold by the government to the private sector without further authorisation by the Parliament. So you can see the mechanisms whereby assets can be reorganised simply by ministerial directive to bodies prescribed in regulations as being a transport authority, not necessarily a public transport authority, any transport authority, and therefore effectively alienated, privatised, sold or potentially leased in any way, and this Parliament would have no further superintendence of those transactions. So you can see it's not a scare campaign. This legislation will set up the architecture that will enable the privatisation of rail assets forced, as it were, by the requirement to make a 7% return. And how can you make a 7% return when rail fares are 73% subsidised by the government? And everyone knows that the tens of billions of dollars worth of rail assets are a depreciating asset, not an increasing asset.
So what would Labor do?
Item 53 of the bill contains further potentially significant changes. It contains a number of amendments to the current Schedule 4 of the Transport Administration Act. Major changes include a new Clause 13 to permit the Minister for Transport to make an order that severs fixtures from the land, including buildings, but may also include rail infrastructure facilities. A new Clause 13.2 that says once severed, the asset may be dealt with as personal property, which means it can be sold, leased, licensed to anyone as long as there is a power to deal with personal property. New Clause 14.2 says that such an order transferring assets, rights and liabilities to Railcorp, which of course will become Tahi, Residual Transport Corporation or Transport for New South Wales or any of their subsidiaries will not constitute a closure of a railway line within the meaning of 99 capital A of the Transport Administration Act. So they will not need further authorisation of the Parliament. And this is significant because once the Tahi provisions commence and it becomes a SOC, it will own Railcorp's rail infrastructure facilities because Railcorp will be replaced by Tahi. And under Section 20 capital W of the SOC Act, statutory SOCs can, with the prior written approval of the voting shareholders, form or participate in the formation of private corporations, acquire interests in private corporations and sell or otherwise dispose of interests in private corporations, whether or not the activities or proposed activities of any such private corporation are related to the functions of the SOC. 20W contemplates that the investment in the private corporation could be in a subsidiary of the SOC. So a severance order could be made and rail infrastructure facilities owned by Transport for New South Wales could be transferred to a subsidiary of Tahi, a subsidiary SOC. A new Clause 14.2 would mean that if a ministerial order were made severing the rail infrastructure from the land, Tahi could then privatise the operation of those rail infrastructure facilities, for example by a licence or operating agreement with a private sector operator because they are severed from the land. So you see British-style franchising of rail operations, which in any plain language means privatisation. Tahi will not be able to sell or transfer those rail infrastructure facilities directly to a private sector operator because once Schedule 2 of the bill commenced, Item 38 says that new Clause 13.2 protection only applies to a transfer by Tahi if it is to a public transport agency, which under the Act will mean Transport for New South Wales, Railcorp, RMS or the State Transit Authority, Sydney Ferries and their public or private subsidiary corporations. However, if a Tahi subsidiary was formed under the SOC Act, the voting shareholders can approve the sale of fixed assets and investments of a statutory SOC, see Section 20 capital X, or of the main undertaking of a SOC, see Section 20 capital Y. After a ministerial severance order, the rail infrastructure facilities will not be fixed assets, and arguably the subsidiary SOC could then privatise those rail infrastructure facilities because the amendments to the Transport Administration Act say they can be dealt with as personal property. Under the new Clause 14.2, those assets would not be affected by Section 99 capital A of the Transport Administration Act, which prohibits the closure of a railway line by a rail infrastructure owner. Once the shares in the subsidiary SOC could be dealt with, voting shareholder approval and all assets of the subsidiary SOC would go to the purchaser of the shares. The transport asset holding entity will be created by Schedule 2 of the bill as the successor to Railcorp, essentially changing Railcorp's name. It is a statutory SOC under the SOC Act governed by a board of directors. It'll be a CEO. There will be a CEO who may be appointed as a director, and there are a range of provisions. The CEO will be able to be removed by the Governor or the Minister on the Minister for Transport's recommendation at any time or for no reason. The objectives and functions of Tahi, which are in clauses 10 and 11 of the bill, are, of course, that its functions be safe and reliable, but importantly, that it be a successful business, including maximising the net worth of the state's investment in Tahi, and of course, to hold, manage and operate and maintain transport assets owned or vested in it, to be owned or vested in it. While all of these are meant to be of equal value, it is a downgrading of the directive for its operations to be safe and reliable above all else, and that downgrading we think is dangerous. There are a range of other provisions that I could go into, but there are significant objections to the current arrangement, not the least of which is that it is unwinding reforms that have proven to be necessary. When this government came to office in 2011, a major policy reform which it shouted from the rooftops was the creation of an independent transport authority and the abolition of a number of transport agencies to allow better coordination and direction of public transport in this state, as outlined by the now Premier, then Transport Minister, in her speech in the other place on the 6th of September 2011. And I won't go through that, but this legislation is a great step backwards, contrary to the lived experience in terms of rail safety. TAHI will become a commercial, independent, statutory state-owned corporation with a mandate to operate independently and, above all, commercially. And it's this requirement to act commercially, to make a 7% return to shareholders, which is the huge difficulty at the heart of the legislation. Following the tragic rail accident at Glenbrook in 1999, the Special Commission of Inquiry into that accident was very critical of reforms to the public sector, the public rail sector, and the Integrated Railway Authority was split into 4 separate entities: a freight operator, later sold, a railway passenger service operator, a rail infrastructure owner, and a rail infrastructure maintainer. Each of those became statutory SOCs and they operated commercially. The rail infrastructure maintainer even started operating outside of the state. It took the death of numerous railway workers in the tragic Glenbrook rail accident for it to be understood that public rail passenger rail operations should not be split up, they should be integrated. And the Labor government then combined the rail infrastructure owner and other entities into a combined operator. And of course now the government is splitting them up again, and we think that is placing public safety at a risk. And the requirement of the SOC to make that commercial 7% return on depreciating assets, on heavily publicly subsidised services, sets a time bomb at the heart of the organisation, which will force it, because it's mandated to act commercially, to sell off everything of value that it owns. You can call it leasing for 99 years, or privatising, or just outright sale. There will be no other way this body could conceivably make a 7% return, and that is just the facts of the case. Missing from the bill is that TAHI is not prescribed as a public authority under the Roads Act, which means if the body needs to compulsorily acquire a public road from a council or public transport project, it will have to compensate councils under the full valuation of the land, whereas other SOCs are exempted. But it's quite clear that this very carefully thought out architecture is designed simply to bolster the government's fraudulent cooking of the books in terms of the budget and make the budget look nearly $10 billion better off. But because of the requirement to have such a high commercial return on the assets, which are just unaffordable without selling everything of value off, and then because of the splitting up of these different functions and because of the mandate to make them operate commercially, history shows that corners will be cut, maintenance will be cut. Maintenance is already running. There's already a maintenance backlog in rail services. This will compound that problem and will place the public at risk once more. And for any one of these reasons, the legislation should be thoroughly rejected. But because the architecture of the bill suffers from all 3 flaws, this House should join with the opposition and say no.
The Honourable